Okay.
Democrats, everybody's welcome.
When in Ohio, do what California
No
does.
wackadoodles. No wackadoodles. Good morning, or good afternoon. Shout out to Mark. We have some information on your seats, I believe, including an article that appeared in this morning's Sandusky Register regarding Mike DeWine. According to the Sandusky Register and the reporting, it is clear that Mike DeWine interrupted and then disrupted a sexual harassment claim that was being made within his office for reasons we're not quite sure of, but I'm about to speak more specifically to. The investigation that was pointed out in today's Sandusky Register began when a former Attorney General's office intern turned down a full-time position she had previously accepted. That intern was a paid law student. A whistleblower within the office gave information about the identity of a possible harasser within the Attorney General's office, and the alleged harasser was described as a close personal friend of Mike DeWine, who worked in the AG's office as well. Despite repeated resistance from the investigator, Mike DeWine insisted that she provide the name of the whistleblower, which in fact the investigator of this sexual harassment claim did. The investigation ended 3 days later with no findings. Among those who the Sandusky Register and others who have researched this indicate were possible harassers was the name William Shank. Mr. Shank has known Attorney General Mike DeWine in both personal and professional relationships for more than 40 years. Shank, as you all remember, was charged with drunk driving in December 2013, shortly after being involved in high-profile prosecutions in Steubenville and Sandusky. Shank denied knowing the victim in the harassment investigation. We have many, many unanswered questions. Why did the investigation come to such an abrupt halt? Why did Mike DeWine repeatedly ignore the investigator's objections that disclosing confidential informant would violate the assurances that the investigator made in the course of the investigation? Essentially, the Attorney General, the Chief Law Enforcement Officer of the 7th largest state of the Union, involved himself in an internal sexual harassment investigation and then muscled into the investigation, compelling his subordinate, the head of that particular division that looks into these kinds of claims, to provide confidential information, including the name of the informant, to the Attorney General of this state. What did Mike DeWine do after learning who the whistleblower was? And why is there no record? Why has Mike DeWine's office not provided any documentation? Have there been other sexual harassment allegations before or since this complaint against the individual in question? Has Mike DeWine ever involved himself in any sexual harassment claim in the largest law office in Ohio? What other internal investigations has Mike DeWine interfered with? How can anyone in Mike DeWine's office feel confident that they can report misconduct now when they know the guy in charge of the office is going to come and find out who you are and pressure you to either be quiet or provide the information that he needs to kill the investigation? Were any other complaints filed against Mr. Shank or other issues during his time at the AG's office besides his very public DUI arrest? Since Shank was moved into part-time status before his DUI arrest, was the sexual harassment claim the reason? If not, what was the reason? Was anyone in Mike DeWine's office disciplined for their conduct? If not, why not? When DeWine told the investigator that the accused, quote, would not find out who the confidential source was, who exactly did he think the accused was when no specific person in the investigation was ever identified? Was Bill Shank ever disciplined by Mike DeWine's office over the DUI arrest or anything else? As all of you remember, as Lieutenant Governor of the state of Ohio, Mike DeWine was embroiled in a scandal, and his attorney, who testified before the Inspector General at the time, Bill Shank. Are there any other issues regarding Bill Shank's employment that Mike DeWine has not publicly disclosed? I point to you the timeline. On April 10th, 2013, the Human Resource Director for the Attorney General's Office is told that the victim has rejected an offer for full-time employment for personal reasons. Upon investigation why, the HR Director discovers, quote, it sounded as though the victim had been victimized or harassed in a sexual nature. The alleged perpetrator was described as an Attorney General employee high up in Mike DeWine's kitchen cabinet, close to the Attorney General, much older. Those are direct quotes in the file. The HR Director informs the Chief Operating Officer of the Attorney General's Office of the report. One day later, individuals within the Attorney General's office seek out the first Assistant Attorney General, the hand-picked political appointment, Mary Mertz. And it's decided that the employees concerned will discuss with the victim the allegations of the day before. They do just that. In her words, the victim describes the aggressor as an Attorney General employee, much older, someone who knew the family outside the office. The victim would not confirm which office, what floor the perpetrator worked on, but indicated that the majority of the situation happened before she started working at the Attorney General's office, as it started happening prior to her being paid as an employee, rather as a paid intern. The victim described the situation as sexual in nature. The victim said she was 18 at the time. The victim was given 4 names by the individuals investigating this allegation. Among those 4 names was Bill Shank. 2 days later, Mary Mertz makes the decision to review all of the victim's emails. 1 day later, individuals within the Human Resources Department of the Attorney General's office finds nothing to substantiate the claim and move to close the file. It's then the Human Resources Department again meets with the victim, and the victim indicates that the comments that were continued to be made her feel uncomfortable. The relationship was sexual in nature and a mistake. The victim now characterizes the relationship, in addition to be a mistake of sexual nature, as harassing behavior. Physical touching, perhaps not criminal, but consensual. His words that made her feel uncomfortable. Friends, at no point there has the EEOC within the Attorney General's office been contacted. On April 19, in an in-person interview, the victim submits a formal letter of investigation. 9 days after first coming to the Attorney General's office. 2 days later, Mary Mertz, the Chief Assistant Attorney General, contacts Franklin County Prosecutor Ron O'Brien and asks for an investigation of criminal conduct. Mary Mertz's email of April 25th indicates that DeWine discussed the case with Ron O'Brien. The Attorney General's office is the largest law firm in the state, in the Midwest. It is essentially run by the Attorney General, who likes to call himself the Chief Law Enforcement Officer. A paid intern going through law school has made assertions about a superior harassing her in a sexual way, perhaps sexual abuse as well. And the Attorney General called the county prosecutor. As all of us know, the Attorney General of this state and the county prosecutor, Ron O'Brien, are close personal friends dating back almost 30 years. Why was none of this ever immediately referred to the EEO officer? Even though the victim continues to revise her statements, there is sufficient reason to believe at least some inappropriate conduct at some level occurred between the perpetrator and the victim. Yet the EEO officer was not contacted. It wasn't until after the Franklin County prosecutor interviewed the victim was the EEO officer contacted. That investigation occurred June 26, 2013, and it became clear through the course of that 4-day investigation That, in fact, one of the 4 individuals previously identified by the victim and by those interviewing the victim originally, one of those was Bill Schenck. On July 17th, 2.5 months after this harassment claim, 2 months rather, after this harassment claim was first known, the Attorney General of the state of Ohio demanded to know of the Equal Employment Office's director the identity of the confidential informant that informed those who lead the day-to-day operations of the Attorney General Office, what the identity of the confidential informant was. The EEOC director and those who work with her, to their credit, refused that strong-arm tactic, at least initially. The Attorney General of the state of Ohio intervened and demanded to know the confidential informant's name of an internal sexual harassment claim that had made its way to the county prosecutor's office. That demand continued for the following 2 weeks. On August 5th, 2013, the Equal Employment Opportunity Director met with Mike DeWine. Mike DeWine asked for and then received the name of the confidential informant. Yet again, he asked for and then he finally received the confidential informant's name. According to records, the EEOC director stated, the Attorney General stated, "Give me the name." 2 days later, the investigation's closed. What did the Attorney General need to know? Why did the Attorney General need to know the name of the confidential informant? And why did the Attorney General even know a confidential informant existed? It's especially important that we recognize. Again, this is one of, if not the largest law office in the Midwest. Thousands of employees, hundreds of attorneys. Yet the Attorney General, the individual who is charged with running the office, actually intervenes to inquire who the confidential informant was who had gone and reported these allegations and started this investigation. The Sandusky Register followed up this morning with a couple of additions to the original story, which made clear that the Attorney General's office knows who the perpetrator is. They've indicated that they know who the perpetrator was, who the perpetrator is. They can tell us. They can tell us who this person is, whether they are still employed, whether in fact it is Bill Schenck as I've asserted, and what they have done to mitigate and to deal with this particular sad chapter. Unless they tell us we know this, that someone within that office has been accused by a paid intern at the time going through law school of sexual harassment, perhaps even sexual abuse. And as a lawyer, he's duty-bound to report that name. As a member of the bar who takes an oath, he's duty-bound to report that name. Over the course of the last year, the Ohio Democratic Party has submitted numerous public records requests. And each and every step along the way, we have been denied and delayed. But as we found out this morning, the truth, albeit delayed, is at least provided for. I welcome any of your questions.